Very recently, Reliance, practically India's number one company, took the internet by storm. That's right. All over the internet news, there were articles about how Reliance went guns blazing against a young techie. A young techie who had an ambition to go to Harvard University. And how did he plan on achieving this ambition? He was planning to employ a certain strategy which many others may think of as very clever or interesting. However, as a lawyer who deals regularly in intellectual property, I neither found his strategy clever nor interesting. This is because his strategy revolved around cyber squatting of a domain name. And I would like to tell you that I would still found the case interesting rather than his strategy because I have recently dealt with a very similar case against another domain name cybersquatter for another company, entirely different case. And that's why when after I was dealing with that case, suddenly this Reliance Jio Hotstar domain name cybersquatting case, which you must have guessed by now that I that's what I'm coming to, was in the news. I found that news to be very interesting. So what followed after this person employed this strategy is very interesting, right? It was a very interesting dispute. So you see, this young man knew that Reliance's Viacom and Disney Plus Hotstar were about to have a merger, and he registered the domain name Jio Hotstar deliberately, knowing that Reliance will come after him to ask for this domain name. And that's exactly what happened. When Reliance asked him to transfer the domain name Jio Hotstar, the techie demanded large sum of money. And to be precise, he demanded 93,345 pounds, right? Which amounts to 1 crore 1,37,920 rupees, right? And he claimed that he wanted to fund his Harvard education by using this money. So, well, no matter how noble this man's intentions were of studying further, an entity like Reliance didn't get where it is today by caving in. They threatened legal action, claiming that Jio and Hotstar were trademarks and that the techie's registration of the domain name without any intention of actually using it and profiting from future sale of this domain name would fall within the definition of cybersquatting, which is an intellectual property infringement. Well, the dispute still remains unresolved, and the reason I told you about this recent controversy is that there are very few people who understand the legal implications of practices as serious as cybersquatting. And I can say that because, of the very recent cyber squatting case that I've dealt with that I was just referring to about 5 minutes back. So, very recently, I was engaged by a client based in India who sells products under the registered trademark of his in more than 20 countries across the globe. And his domain name with .com consists of his registered wordmark, right? He's registered a certain trademark, and his domain name, the one with .com, has this wordmark in it. But he also wanted to register a domain name with the same wordmark with .in. So when he searched for the domain name with that wordmark, with the name of his brand and .in, he was surprised to find that somebody else had already registered that domain name. This is when he reached out to me and asked me to get in touch with that person to help him buy that domain name, the one with .in, because .com one he already had. So the very first thing I told this client is that there's no absolutely no need to jump the gun and go and ask that person to buy back this domain name. Instead, I advised him to send a legal notice first to the registrant of this domain name. And I suggested that because my client had a registered trademark for the word that the other person had registered a domain name for, right? And my client had this trademark not just in India, but also in 20 other countries. So he registered this trademark, the word which consisted of the domain name .com, the one which we wanted to also buy the .in one for, in India and about 19, 20 other countries. And secondly, this other person was not even using the domain name that he registered, right? So the person, the cyber squatter, was not actually using the .in domain name that he registered. He had just registered it just for the sake of registration, knowing that okay, one day somebody will come along and ask to buy that. So this, ladies and gentlemen, what this other person was doing is a practice known as cyber squatting. And it's the practice of registering a domain name without any intention of using it. And then demanding money from another party who actually wishes to register and use such a domain. It also becomes a case of intellectual property infringement, where the domain that is registered is also the intellectual property, such as a registered trademark, of the person who seeks to register this domain name. So then, as I advised my client, I sent a legal notice to this infringer and cyber squatter, asking them to transfer the domain name to my client. After a few negotiations over email and a virtual meeting, This third party agreed to transfer the domain name to my client and acknowledging that my client had intellectual property rights in the domain name and that he had no interest in keeping this domain anyways. So at most he asked for some minor expenses. Initially he had asked for larger sum, but because we had the law in our hand, so we brought that offer of his down to some basic expenses that he had registered the domain name in. And then we asked our client that okay, if you want, we can even file a case against him, but it's up to you if you would rather just close this matter or would you rather go to court. So my client agreed that okay, he'll pay a small sum of money, basic expenses to this other party, and buy back the domain name. And in this way, we basically closed this matter efficiently. We also drew up a settlement agreement between the parties, asked them both to sign it. And in this agreement, we clearly specified that the domain name was being transferred back to our client, and our client has the intellectual property in this domain. I mean, in the future, this third party should not be using any domain name or other form of intellectual property which is similar to our client's registered intellectual property. So in this way, we basically, by using the power of law, we were able to very effectively negotiate with this third party and get him to transfer the domain name, which was rightfully that of our clients anyways, because that domain consisted of the same words which were the registered trademark of our client. So that's why, my friends, I would say that the techie did nothing clever by squatting upon the Jio Hotstar domain name. You should know that there is a famous judgment on Yahoo about domain name cyber squatting in India, and Indian law recognizes cyber squatting as a form of IP infringement and as an illegal act. And you should also know that an IP infringement lawsuit can be filed in court against a cyber squatter by a registered IP holder of the word that the domain name consists of. So parties also have another option other than filing a lawsuit before a court. They have the option of approaching the NICSI for domain name disputes for .in disputes, or for approaching the WIPO for domain name disputes which are related to .com domains. So these are some of the forums which facilitate resolution of domain name disputes through arbitration. So folks, that's it for today. I hope that you found today's episode to be useful and enlightening, gave you some knowledge about domain name disputes, and I hope that you keep coming back to watch more episodes and get more knowledge about IP and tech law through my episodes. Thank you.